Evan Wolfson is founder and president of Freedom to Marry, and Tony Perkins is president of the Family Research Council. Gentlemen, thank you both so much for being here. It's great to see you.
Good to be with you.
Good afternoon.
Let me start with you on this, Tony. What does it mean? DOMA had a tough day in court today, and in DOMA's defense, it didn't have the federal government there to defend it as it normally would. Normally, a federal law gets the defense of the Department of Justice, and President Obama declined to do that in this case because he doesn't believe the law is constitutional. So they had to go out and hire Paul Clement, who's a very skilled advocate, and he defended the law. If it's struck down, what does that mean?
Well, as you know, Megan, there's two components to DOMA. One is protecting the states and their definition of marriage, and then the second, which was at question today, was the federal definition of marriage, what DOMA does. Government, defining it, as you said, as a man and a woman. Well, first, the fact that the government didn't defend it may have a bearing on what the court does with the case. But if they do strike it down, the bigger question then becomes, how do you define marriage in this country? Because the federal government obviously does have a compelling interest in defining marriage when it comes to what it gives benefits to, or what it gives money to, or subsidizes. So the door then is open even broader as to how we define marriage.
I want to ask you, Evan, because as I see it, if DOMA is struck down, it doesn't mean that gay marriage is now legal in the country. Unless the Supreme Court goes way out on a limb and rules, and the reason it's unconstitutional is because of the Equal Protection Clause, but the argument, summations I've read, nobody seems to think they're going to go that far.
Well, the Defense of Marriage Act, so-called, is the federal law that says that we're going to have a gay exception to the normal way the federal government treats married couples. All other married couples who get married by licenses issued by the states or other countries, the federal government doesn't issue marriage licenses. All married couples get all kinds of federal protections and responsibilities, tax treatment, immigration protections, access to health care, Social Security, and so on, except for gay couples.
So you don't have to be married twice in this country. If you get married, I marry my husband in New York, I don't have to go get married at the federal level too. I'm married, period. That's
exactly right. And for more than 200 years, the practice has been that the federal government honors the marriages that are legally celebrated. But there's a gay exception created by this law. And what the court was looking at today is, can you have a gay exception to a law? Can the federal government say, we're going to honor all marriages that states license, except the lawfully married gay couples who are going to get none of the federal protections and responsibilities, not the taxes they pay,
and the woman,
not the Social Security
who brought
they
this case is an 83-year-old woman who got married to her lesbian in Canada, and then her partner died, and she had to pay $300,000+ in estate taxes that she would not have had to pay if she had been married to a man, and that is the plaintiff in this case. But Tony, what is the answer to Evan's question about whether the federal government, as he phrases the issue, can exclude gays from this, recognized marriage?
Well, it's the definition of marriage. What is marriage in this country? And, of course, 30 states have placed the definition of natural marriage into their state constitutions. But you raise a good point about the fact that this couple was married in Canada. What happens if a man is married in the Middle East and has multiple wives, wants to immigrate into this country? Does that now force the government to recognize polygamy in this country? So there is a compelling reason for the government to have a definition of marriage. And the definition that the federal government has had under DOMA has been consistent with the vast majority of states in this country.
I want to get to that, Evan. I want to get to that because Tony and others have raised this issue of, if you've got a fundamental right to marry, whether you're straight or gay, whatever you are, you've got a fundamental right to marry in this country, then there has been a concern raised by some that would then open the door to polygamous marriage down the line, because a polygamist will come in and say, I have a fundamental right to marry, and in my religion, we marry 3 people. And it was Justice Sotomayor, a Barack Obama appointee to the bench yesterday, who asked the litigants that question. Listen to her.
If you say that marriage is a fundamental right, what state restrictions could ever exist? Meaning, what state restrictions with respect to the number of people, with respect to that could get married, the incest laws, the mother and child, assuming that they're the age. I can accept that the state has probably an overbearing on protecting a child so they're of age to marry. But what's left?
Evan?
Yeah, well, actually, it's very simple. First of all, the Supreme Court has acknowledged that there is a freedom to marry. That is a fundamental right. This is not a new question. The freedom to marry has been recognized as something belonging to all of us under the Constitution in at least 14 Supreme cases.
It has, but the question is, do you have the right to marry another gay person? Or
no, I understand that.
Yeah, so
that's exactly. Well, the question is, what reason does the government have for denying the freedom to marry to gay couples? And the answer to the question you're putting up here is that gay people are not saying, let's have no rules, let's just do anything. What gay people are saying is, let us have what you have. Just as you have the freedom to marry the person you love, the person you're building a life with, and take on that legal commitment and responsibilities, so should we. Other questions are other questions, but the question of what reason is there to deny couples who've made that commitment in life just because they're gay is the question before the court.
That gets right to it. That gets right to it,
What was striking, just let me say one quick thing.
Because I'm short on time, but I want to get Tony's response. Sure. This is an important point. What is the reason? He is right that it seems like the court is accepting that states can draw a line somewhere. It's not just going to be anybody can marry anybody or anything. That the states can draw a line somewhere. But he says there has to be, a compelling interest, and there's an argument about how compelling the interest has to be. There has to be a good reason. And Tony, let's get to that. Let's get to what is the reason that gays should not be allowed to marry.
Let's look historically at why the government has defined marriage as it has. It's followed the natural definition of marriage, and we've amassed decades of social science research that shows that the government has a compelling interest for kids to grow up with a mom and a dad. Not just two parents, but a mom and a dad. That's why the government has extended benefits to marriage, because marriage benefits. But if you want to talk about rights, let's talk about the rights that have been lost in those places that have created same-sex marriage.
Can I answer what Tony just said here?
Let's talk about the loss of religious freedom.
Before we change the subject.
Let's talk about the loss of parental rights. Let's talk about the loss of business owners that have been fined or have been sued because they haven't participated in same-sex marriages, either photographers or those who bakers. So let's talk about the rights that have been lost in those jurisdictions that have created same-sex marriage.
Go ahead, Evan.
We could talk about it.
Let me give it back to Evan.
Fundamentally altering America.
Go ahead, Evan. Answer that question if you could. About Tony's suggestion on the studies of a mom and a dad, not just two parents.
Right, exactly. That's a really crucial point, because Tony Perkins had the chance to go into court along with whatever other witnesses he and his side wanted to produce and prove what he's saying. And the fact of the matter is, the trial held 7 weeks of testimony, evidence, and cross-examination, and there was zero evidence produced, because Mr. Perkins keeps saying there are all these studies and so on, but the record is crystal clear. There are no such studies. It is simply not true.
You're absolutely wrong.
You can say I'm wrong, but when you had the chance to go into court, you were silent. The truth of the matter is that
you should read
in front of this court, your amicus brief is your group, but you haven't been able to produce a single public health, psychiatric, child welfare association that has said it. In fact,
I got to go because I'm up against a heartbreak, but Tony, I just want to ask you, separate and apart from the mom and the dad issue, I mean, what we've heard from the Supreme Court justices is we've got 2,000 years of history on this. We got, 5 to 10 years of gay marriage rising as a trend in this country. Why should we be the arbiters of what's now okay in the country? Do you see this as more of a democracy issue for the states?
Look, the states are working this out. If it was inevitable, as some would like to say, the court should interject itself in this. Look, you don't make radical public policy changes like this overnight. There are unintended consequences when we do things like this. It's out democratically. We shouldn't label our opponents bigots. We should allow the American public to discuss this and reach a consensus on this.
I agree with you on the labels. Let's leave it at that. Leave it on a high note. Great debate.